Hello, good morning friends. In this present webinar, I'm going to discuss an important judgment of Hon'ble Rajasthan High Court which is quite recent in time. The judgment has been pronounced by Hon'ble Rajasthan High Court in the judgment titled as Babulal versus State of Rajasthan. It has been pronounced on 16th of August 2024. It is pronounced by Justice Birinder Kumar. The concerned appeal number is 2556/2023. In this case, the accused has been convicted and money was recovered from him, and apart from that there was a demand. It was the observation by the concerned trial court judge. The concerned case is that the complainant was a teacher. He applied for a loan to the concerned manager, and his story is that when the loan was applied to pass the loan and for the purpose of sanctioning the loan, the money was demanded, that is rupees 5,000 as a bribe. In the meanwhile, he went to the concerned Anti-Corruption Bureau, lodged the report, finally a trap was organized and he was caught red-handed. But the key point is that the money is not recovered from the person of the accused, it was recovered from the table drawer. That is a very important point to be noted down, because if the money is not recovered from your person, in that scenario you could have the benefit in the light of judgment of Honorable Supreme Court titled as Meera versus State of Maharashtra. And apart from that, the key point is that in that scenario, the concerned complainant had averted the false fact to the concerned Anti-Corruption Bureau, because he submitted in the report that for the purpose of loan sanctioning the amount has been demanded. But the key point is that before approaching to the concerned ACB office, the loan has already been sanctioned, so there is no pendency work. So still pendency work is one of the most important criteria which is to be remembered in our mind. If there is no pendency, in that scenario we could easily get the benefit. And apart from that, there are certain circumstances on the record which are to be borne in mind while arguing these cases. In addition to this, he submitted that the application for loan was received in the month of August 2009. On 8th of September 2009, the amount was transferred to the account of complainant after sanctioning the loan. He submitted that the concerned complainant is a heavy drinker, and apart from that he used to misbehave with the bank employees, and he was totally aggrieved by the approach of the concerned bank, because against the demand of rupees 1 lakh as a loan sanctioning, only the loan of 80,000 rupees has been sanctioned. So he was aggrieved by the same. He was of view that the exact amount that was demanded should be sanctioned as a loan. Friends, you know that the loan sanctioning process depend upon your credit, and apart from that, usually the bank used to grant 80% of the loan that is submitted for the purpose of sanctioning. Friends, in this case, the concerned demand and acceptance was not proved by the concerned prosecution. That is important plea taken by the defense during the course of argument. As you know that demand is one of the most important criteria in the anti-corruption cases. If demand is not proved, it is not specific, it is general. And apart from that, the story of the concerned complainant in the report is not going to be matched with the story of the concerned prosecution averted in the transcription or recorded in the transcription, whatever the case may be. In that scenario, we could have the easily benefit, because on the point of corroboration we could hit out. And apart from that, if there is no acceptance, then again we could have the benefit. But even though there is acceptance, but the key point is that mere recovery, mere acceptance cannot be ground to assume that you are a culprit. The prosecution is required to prove the case beyond reasonable doubt. Apart from that, the factum of the alleged recording that the voice recording belongs to you is required to be proved by the concerned prosecution in light of guidelines of Honorable Supreme Court verdict titled Ram Singh versus Ram Singh, in which it is specified that the record should not be manipulated. Apart from that, its hash value, its proper property are required to be mentioned on the record. Apart from that, the case of Imam Saab versus State of Karnataka, the judgment was also helpful in the present case as well, because in the case the court observed that if the concerned accused is to be convicted, the prosecution is required to prove the demand, and if demand is not proved, it is not specific, the accused could have the benefit. The judgment is pronounced by Honorable Supreme Court. That is very important. And apart from that, judgment of A. Subbe versus State of Kerala was also relied upon, and court specified that demand and acceptance of bribe is must. If demand and acceptance is not accepted, in that scenario the accused could be acquitted. And apart from that, the color test is required to be positive, and color test must not be manipulative. It should be done spontaneously as observed by Honorable Supreme Court in case of N. Vijay Kumar versus State of Tamil Nadu. And apart from that, concerning the pendency of work, we are having Katinov judgment. In judgment of Chandresha versus State of Karnataka, Honorable Supreme Court specified that the pendency of work is one of the most important criteria. If there is no pendency of work and already work has been done, in that scenario the accused could have the benefit of said scenario. In the present case at hand, the amount was already sanctioned, it was dispersed, it was withdrawn, and all these facts has been considered. Even the vigilance has not shown any trouble to verify all these facts. Apart from that, the fatum of recording is highly doubtful, and in that scenario, the accused has relied on the judgment of Ziauddin versus Brijmohan. The judgment was pronounced by Honorable Supreme Court in the year of 1976. It is to be specified that the recording is genuine, the consent record has been properly identified, and apart from that, the shadow witness is also going to be corroborate on the line of the consent transcript, consent audio, and the consent story of complainant. If all the guidelines are not there in that scenario, the fact of recording cannot be said to be genuine, and apart from that, the voice record is required to be identified, and apart from that, the possibility of tampering should be ruled out by the consent prosecution is required to be followed as observed by Honorable Supreme Court in case of Ram Singh versus Ram Singh. Judgment is pronounced in the year of 1986. So in this case, the concerned complainant inter alia not verified the voice of the concerned accused. The accused voice sample has not been taken, and apart from that, he has not identified nothing about his own voice, about the voice of the accused, and apart from that, the concerned shadow witness also not identified the voice of the accused and complainant, and apart from that, he has not given the same statement as given by the concerned complainant to corroborate the story of the prosecution, because the complainant story is that the demand is made regarding the said work, but there is nothing in the statement of the concerned shadow witnesses regarding the same. So when the sound is not clear, there is background noise, and apart from that, the work is not pending, and there is no corroboration on each and every point. And apart from that, the concerned defense has taken the plea that he has not demanded the amount voluntarily as a bribe. Apart from that, it is basically a legal gratification. He submitted that the amount is taken from him because it is totally a processing amount which is required for the loan. Although it is a very dangerous defense, but he has taken this defense. He submitted that the concerned accused inter alia take the money because the processing fees is to be applied while sanctioning the loan, that is 5,000 rupees in the present case, and he submitted document to sustain his defense, and the court found the same defense as probable. And apart from that, he submitted the citation of N. Sukarna versus State of Andhra Pradesh, in which it is specified that mere recovery cannot connect the accused with the crime, and apart from that, if gratification is legal, the accused cannot be convicted. And in the judgment of B. Jayaraj versus State of Andhra Pradesh, in judgment of P. Satyanarayana Murthy versus State, the same principle has been adopted. So when the spontaneous explanation has been given by the concerned accused on the spot that money is not taken by him as a bribe, and apart from that is a legal gratification, and other evidences are weak, not connecting, not corroborating, then accused could be acquitted from the charges. So this judgment is going to teach us the following 5 principles. Number 1, the concerned complainant or the prosecution is required to corroborate the case on the touchstone of demand and acceptance. If demand is not proved, the accused could not be convicted. Number 2, the concerned prosecution is duty bound to specify that there is a work which is pending, and for the said work, as a motive, the money has been demanded to complete the work. If such a scenario is not on the record, it is concealed, and apart from that, they are not corroborated or verified, the defense could have the benefit. Number 3, the concerned prosecution is required to prove that the demand is voluntarily. If it is not voluntarily, it is not corroborated, then we could have the benefit. Number 4, if there is any letter on the record, they are required to prove that it is not tampered and it is as per the touchstone of the Honorable Supreme Court guidelines. If it is not there, we could have the benefit. And apart from that, they are required to specify that the shadow witness is going to corroborate the entire scenario without any hesitation. If all criteria are not satisfied in that scenario, the accused could have the benefit without any worry. So friends, an important update, please follow these guidelines in your case and definitely we will win. The key point is that if you are not able to fight your case and we are not able to acquaint with the legal knowledge in that scenario, we could have a damage in the case. So if we are ready to work on our fact, we are ready to work on the law, then we could have the benefit. So friends, see you in the next video. Till then, Jai Hind, Jai Bharat.